Okay. Let's open this session of Parliament. I welcome members to the 18th meeting of in 2013 in the Subordinate-Legislation Committee, and I would ask members to switch off phones. We've received apologies from Nigel Don, who has business elsewhere. Agenda item 1, instruments subject to affirmative procedure. No points have been raised by our legal advisors on Debt Arrangement Scheme Scotland Amendment Regulations 2013 draft or Public Services Reform Functions of the Common Services Agency for the Scottish Health Service Scotland Order 2013 draft. However, members will recall that the committee took evidence from Scottish Government officials on the consultation draft of the Public Services Reform Instrument at its meeting on 19th March. The committee raised a number of questions as to whether the Scottish Government had satisfied the test for modifying the functions of the Common Services Agency through an order as opposed to primary legislation. Additional information included the explanatory notes and policy memorandum accompanying the order demonstrates that the Scottish Government has given consideration to the concerns raised by the committee. Further to this, members may wish to note that the drafting error which was raised by the committee when it considered the consultation draft has been corrected. Is the committee content with these instruments? Agenda item 2, instruments subject to negative procedure. Children's Hearing Scotland Act 2011, Rehabilitation of Offenders, Transitory Provisions Order 2013, SSI 2013/146. Members will recall that the committee took evidence from Scottish Government officials on this instrument at last week's meeting. The evidence session focused on the competence problem that has arisen with the implementation of the Children's Hearing Act 2011, insofar as it interacts with the Rehabilitation of Offenders Act 1974. Our focus today is on whether the instrument should be reported to Parliament under any formal reporting grounds. Article 24(a)(2) of the order modifies the effect of Section 5(3) of the Rehabilitation of Offenders Act 1974 to apply to cases where there is the discharge by a children's hearing or, as the case may be, the sheriff, of the referral of the child's case to a hearing under sections 94(2)(b) and 114(3)(b) of the Children's Hearing Scotland Act 2011. The Scottish Government has confirmed that the reference to these provisions of the 2011 Act has no effect, as none of the outcomes which are possible in terms of these provisions engage the rehabilitation scheme set out in the 1974 Act. It is also undertaken to amend the order to remove the reference to these provisions at the next opportunity. However, the committee may consider that these erroneous references in a highly complex instrument could cause confusion to those operating the provisions of this order, or could lead to other detrimental effects. The committee may therefore wish the Scottish Government to make a corrective amendment as soon as possible to avoid this occurring.
I would agree with that view, Convener, and I think we should insist on a corrective amendment being made as soon as possible. There has been too much confusion already around this piece of legislation, and anything we can do as a committee, I think we should do, almost as a point of principle, to try and reduce that confusion and therefore make the correction as soon as possible.
Thank you. Does the committee agree to draw the order to the attention of Parliament on the general reporting ground as certain provisions in Article 242 have no effect? Does the committee also agree to recommend that the Scottish Government makes a corrective amendment as soon as possible? Moving to Children's Hearing Scotland Act 2011, Transitional Savings and Supplementary Provisions Order 2013, SSI 2013/150. The meaning of this instrument could be clearer in relation to the following matters. The meaning of Article 2(5) could be clearer in two respects. First, the provision purports to apply to, quote, any enactment, when the Scottish Government has confirmed that it is intended only to apply to enactments other than those set out in Article 2 brackets 2 and for which different provision is made in Article 2 brackets 1. Secondly, the Scottish Government has confirmed that the intention underlying Article 2 brackets 5 is to make a general saving of those other enactments as they apply before the commencement date of this order to, quote, relevant proceedings, which are in progress on the date of commencement of this order. Some such enactments will either be repealed or modified on the date of commencement of this order by virtue of provision made in other legislation implementing the Children's Hearing Scotland Act 2011. The meaning of Article 2 brackets 5 could be clearer to implement the Scottish Government's intention. On one interpretation, it purports to prevent any enactment which might be passed during the period until the, quote, relevant proceedings have concluded from modifying or repealing any existing enactment which applies to the proceedings. That period might end on a date later than the commencement date of this order. This order cannot entrench the position to prevent a change by such a later enactment. Finally, the meaning of Article 2 brackets 1 could be clearer. It provides that the reference to the Legal Aid Scotland Children Regulations 1997 made in Article 2 brackets 2 bracket D is, quote, subject to the following provisions of this order. Those provisions include Article 27 brackets 1 and 2 brackets A, which revoke the 1997 regulations. Confusion could be caused by the two incompatible directions. The direction that the 1997 regulations continue to have effect and the direction that they are revoked. It could have been made clearer that the revocation is intended to be subject to the provision in Article 2, which saves the application of the 1997 regulations to proceedings which are in progress under the Children's Scotland Act 1995 as at the commencement date of this order. Does the committee therefore agree to draw the order to the attention of the Parliament on reporting grounds H, as its meaning could be clearer?
Yes, can I just endorse that? Because, I mean, we have two incompatible directions, and so therefore to say, I appreciate it's the gentle legal language that we use, but it's really a little short of ridiculous to have two incompatible directions when it would have been simpler and should have been picked up that they are or are now going to be incompatible. So.
Right, the official report will of course now contain those comments. Moving to Animal Health, Miscellaneous Fees and Amendments Scotland Regulations 2013, that's SSI 2013/151. References to EU Collection Centre, EU Quarantine Centre and EU Storage Centre should be to EC Collection Centre, EC Quarantine Centre and EC Storage Centre to reflect the services provided under the Bovine Semen Scotland Regulations 2007, in respect of which fees are to be charged. This lack of clarity is unlikely to cause confusion, and the committee may wish to note that the Scottish Government will amend these references to provide clarity at the next available opportunity. Does the committee agree to draw the instrument to the attention of the Parliament under the general reporting ground as it contains minor drafting errors? Does the committee also agree to note that the Scottish Government intends to amend the incorrect references at the next available opportunity? No points have been raised by our legal advisers on Sheriff Court Districts Amendment Order 2013, that's SSI 2013-152, Justice of the Peace Scotland Amendment Order 2013, that's SSI 2013-153, Town and Country Planning Control of Advertisements Scotland Amendment Regulations 2013, that's SSI 2013-154, Town and Country Planning Development Management Procedures Scotland Regulations 2013, that's SSI 2013-155. However, in relation to the Justice of the Peace Courts Scotland Amendment Order 2013, SSI 2013/153, whilst no formal points have been raised by our legal advisers, the committee may wish to highlight a potential policy issue to the lead committee. As Justice of the Peace Courts and Sheriff Courts have different sentencing powers, there is a potential for a higher sentence to be imposed on persons whose cases are being transferred from a closing Justice of the Peace Court to a Sheriff Court if they are convicted or sentenced after the transfer. Is the committee content with the instruments? Content.
I would just say, you know, I think we should be grateful to our advisers for highlighting that point. I hope the Justice Committee take note of them.
In that context, does the committee agree to draw the matter raised in relation to the Justice of the Peace Court Scotland Amendment Order 2013, that's SSI 2013-153, to the attention of the lead committee, while not formally reporting the instrument? Agreed. Agenda item 3, instruments not subject to any parliamentary procedure. No points have been raised by legal advisers on certification of death, Scotland Act 2011, commencement number 1 order, that's SSI 2013-159. The Act of Sediment Lands Valuation Appeal Court 2013, that's SSI 2013/161. The Water Resources Scotland Act 2013 Commencement Order Number 1, that's Order 2013, that's SSI 2013-163. Is the committee content with these instruments? Content. Before I close the meeting, please note this will be the final meeting at which this committee will be known as the Subordinate Legislation Committee. Following Parliament's agreement to the recommendations of the Standards, Procedures and Public Appointments Committee, as contained in its second report of 2013, this committee will from tomorrow be known as the Delegated Powers and Law Reform Committee, and our next meeting will be held on Tuesday the 11th of June. Yes?
Thank you, Convener. I think while I understand that the new snappy name will mean that there is no change in the committee, I think nonetheless it does appear to mean the end of the Subordinate Legislation Committee, and I think we should just put it on the record that this committee has served Parliament well over the last 14 or so years, and I'm not quite sure what more one should say other than perhaps give thanks to those who have convened it, who have clerked it, and the members who have supported it over those years.
I'm sure that the committee would find it easy to agree with that. Is that the case? Yes. I close this meeting of the Subordinate Legislation Committee.